if you find out that someone else is using your trademark or something very similar to your trademark, and they're in a similar line of business or work, then there are several steps that you want to take. And really the first most important step is to stop, to slow down. Don't do anything on your own. Don't reach out to the other company. Talk to a trademark attorney. And the reason is you want to evaluate whether this is a legitimate claim, whether they really are using your mark in a manner that would confuse consumers, whether they are a competitor in either your industry or a related industry of products and services. And you want to make sure that you have the dominant rights, and so it doesn't backfire. What I mean is, if they were somehow using it first and you just didn't know about it, contacting them could actually backfire. If you contact XYZ and say, we think that you're copying our trademark and we demand you stop, and they write back and they say, well, actually, we agree that these are confusing, but here's proof that we were using it first. Now you've actually just created a problem for yourself instead of solved the problem. So you want to make sure that you get the foundation understood in terms of what the facts are before you take action. And if you haven't registered your mark yet, you want to most likely at least start the application process before you reach out to and contact the other business, because if they file before you at the USPTO, that will just cause even more problems and complicate and make the situation even more expensive. If the situation is international, it may change the perspective here and the options, and you may not even have any rights depending on whether you've done business internationally. So that's another factor that you want to consider before taking any action.